Docket number 125, matter of Terranova versus Lehr.
Your Honor, may I reserve 2 minutes for rebuttal?
You may, sir.
Thank you.
You're welcome.
May it please the Court, I'm Robert Gray. I'm representing Appellant Joseph Terranova in this case. We are asking the Court to adopt a very simple and straightforward rule here, which is that any award of workers' compensation benefits that is made after the date of a third-party settlement should follow the rule in Burns unless that future award was already taken into account under the rule in Kelly.
How do we interpret the appellate division's decision? Is that a waiver of additional recovery because they settled?
Your Honor, I believe what the appellate division did is they literally interpreted the dicta in the Burns case that Burns does not apply to permanent total disability or schedule loss. And unfortunately, the appellate division mechanically applied that language and said, okay, this case resulted in a schedule loss award and therefore Burns does not apply. The problem with that analysis is that it completely overlooks the core purpose of the Kelly and Burns decisions, which is, as this Court has said, to equitably apportion the litigation expense between the injured worker and the compensation carrier. So here, if you elevate, as the Attorney General has characterized it, the type of the award over the timing of the award, then you violate the basic purpose of the statute and this Court's decisions in Kelly and in Burns. We believe that the rule that we're advocating for has three redeeming factors. One is it is completely clear and will be easily understood by plaintiffs' personal injury attorneys and workers' compensation carriers. If the workers' compensation case has resolved with a permanency determination, and that permanency determination is a permanent total disability or a death case or a schedule loss award, then everyone will understand that Kelly applies. If it does not meet any of those criteria, then everyone will understand that Burns applies and the Workers' Compensation Board can handle that issue as it has been handling that issue. So we believe if you adopt the rule that we're requesting, there will be clarity for all the parties involved, and that's obviously beneficial.
And the cases have generally talked about foreseeability or calculability of the awards, right?
Yes, Your Honor. The core question.
So they categorize the different kinds of awards, but basically what they were looking at was, can they be ascertained at the time of the settlement, regardless of the nature of the award?
That's exactly right. And the reason schedule loss ended up in Burns is because if a schedule loss is determined prior to the date of the third-party settlement, and the schedule loss results in a number of weeks that run into the future, you could, at the time of the third-party settlement, reduce that to present value and calculate it pursuant to Kelly. The problem here is the schedule loss was not awarded before the third-party settlement.
And just to be clear, so that kind of award would never be changed, whereas other partial permanent disability awards may be subject to change, and that's what Burns was looking at.
The decision in Burns was that because a permanent partial disability award may change based on a return to work or an untimely death or a failure of labor market attachment, that those awards are speculative, and because they're speculative, it would not be fair to the carrier to reduce that to present value and calculate it at the time of the third-party settlement. But to borrow a line from the Kelly decision, to stem the inequity that would occur to the injured worker if the carrier contributed nothing, the court adopted a pay-as-you-go rule to make sure that the compensation carrier paid their fair share. What's going on here is the compensation carrier is taking the position that because it's a schedule loss, they escape paying their fair share, and we don't believe the court should countenance that.
How often do you have this kind of timeliness quirk or time quirk where you have the settlement up front, and that's why, in part, you don't know what that award's going to be from the workers' comp board?
It happens more often than you might think, Your Honor. The closer in time to the date of the accident the personal injury case settles, the more likely it is that there are still unresolved issues in the workers' compensation case. That is, in fact, what happened here, and it is not an uncommon situation.
Does your proposed rule apply whether the third-party action settles or goes to a verdict?
No. The question is not whether the third-party action resolves by settlement or by trial. The question is whether at the time the third-party action resolves, we have a fair degree of certainty, we have a fair degree of certainty about what's going to happen with the workers' compensation award. We will either know that because there's been a classification of some sort or a schedule loss, or we won't. If we know it, then we can apply Kelly. If we don't, then we should apply Burns.
Is there any case law? Wasn't there a third department case, Stenson, that spoke to this issue? That's the only case that I saw that spoke to this
Yes,
issue.
Your Honor. What
Wanna address
happened
it?
after Burns is compensation carriers initially took the position that the Burns rule only applied to permanent partial disability cases. So if you had an unresolved case or an award for temporary disability that was ongoing, their position was that Burns did not apply. The third department clarified that in Stenson and said Burns applies to anything that's not already resolved and determinable and is non-speculative, like a permanent total or a death case. And again, they picked up on the dicta regarding schedule.
So Stenson, do you think Stenson works against you in this case?
I don't. I think Stenson
how so?
works for me. Stenson and Burns, I think both are right in line with Kelly and right in line with what the statute says, Section 29 of the Workers' Compensation Law, which is that the goal here is to equitably apportion the litigation expense between the plaintiff and the compensation carrier. If there is certainty about the resolution of the workers' compensation award, then we don't apply Burns, we apply Kelly.
So
If there is,
are you saying that the court wasn't looking at the situation we have before us now when they decided Stenson and just sort of weren't thinking about that issue?
Your Honor, I have been unable to find any case where the issue presented here has ever been directly presented. That's why I say it was dicta in Burns. Burns did not involve a schedule loss. None of the cases that Burns cites involve a schedule loss, and none of the cases that those cases cite involve a schedule loss.
So are you also saying that it was dicta in Stenson?
Yes, yes. What I'm saying is that the court should focus, the question that the court should focus on is whether at the time of the third-party settlement, the future workers' compensation benefit was certain or uncertain. If it's uncertain, which was the case here, then Burns should apply.
And there's no need for us to get into the determination with respect to the settlement letter that was entered into, but reserving the Kelly-Burns.
There were two settlement letters, Your Honor, as you know. The carrier here issued a consent letter that cited solely to Kelly, and I completely agree that had that been the consent letter in this case, there would have been no reservation of Burns rights. However, that letter was rejected specifically to preserve this claim, and in the second consent letter, there was a specific reservation of rights under Burns in order to preserve this claim, which is why we're here.
Thank you, Counsel.
Thank you.
Counsel?
Good afternoon. May it please the Court. Patrick Woods on behalf of the Workers' Compensation Board. I'd like to make it clear at the outset what the Board and the Third Department did not do in this case. Much of the briefing here has focused on whether this particular award was readily ascertainable at the time of the consent to settlement letter. That is not the analysis that either the Board or the Third Department applied in this case, although it is the analysis that we urge this Court to change the rule to permit the Board to apply. Accordingly, we believe that the appropriate disposition of the case here is for the Court to announce a clarification of the rule that permits a more flexible approach than the one applied by the Third Department. That is
Do you like
based-
Mr. Gray's rule? Is that the rule you would want?
Not precisely, Judge. Mr. Gray's rule is certainly better than the rule that the Third Department applied in this case. We think there are two formulations of the rule that would more fully support the statutory objective here. One is a completely flexible rule that says that either the Board or the court who's being petitioned would at that time make an ascertainability determination based on everything that's in front of it, or a rule that takes the dicta from Burns and makes clear that those classifications of death, total disability and schedule loss of use are presumptive, but not determinative, so that if there's a dispute about whether this particular award is determinable, then the court will get into it.
But
So are
do
you-
do you acknowledge that there's a difference between a schedule loss of use award that has already been made and one that has not? Or even a determination of the schedule loss of use?
Certainly, once the schedule loss of use award has been rendered, it's going to be readily ascertainable, and a court confronted with that situation would have an absolutely easy lift in figuring out that it is readily ascertainable.
But what you're saying is that if it hasn't already been rendered, it may or may not be ascertainable. Is that what you're saying?
That's correct,
Okay.
Judge, and
It sounded to me as if you were saying you'd like Mr. Gray's rule plus some additions. Is that fair or no?
I think, if I'm understanding Mr. Gray's rule correctly, what he would like is timing trumps type, rather than type trumps timing. Our
Right, so
concern-
wouldn't he be asking for Burns, then Kelly after the determination?
I think that's correct, and
So that's really what we're talking about here, the sequence, as opposed to just Kelly or just Burns. In this rare situation, it's Burns, then Kelly,
I think
after the
that's
schedule loss of use is decided.
I think that's generally correct. The reason that we have some reservation with Mr. Gray's formulation is because in a hypothetical situation, it could undermine the appropriate application of Kelly.
Right, so you'd want flexibility to make a determination as to ascertainability, among other things, based on the facts of particular cases.
Correct, Judge, because we can envision a scenario where, for example, you have a schedule loss of use award that has not yet been rendered. There is a third-party judgment, but there's no dispute between the parties as to the degree of the impairment. In that scenario, it would be readily ascertainable, and the claimant should be able to get a lump sum upfront allocation under Kelly. But if you apply a strict timing trumps type rule, then that would not be available to that claimant.
And the likelihood of that hypothetical, in terms of the experience of the board, is what? Is that on the fringes, or is that more regular than not?
I can't give you an exact. These cases are relatively new, and there hasn't been that much development. But the issue is live. As of this morning, there were 4 cases ready for board review that are being held on the outcome of this case. And I would stress that this is an opportunity for the court to nip this issue in the bud before it blooms into a larger problem down the road.
Also, just to clarify, the board never made a determination regarding the settlement letter and whether the carrier had expressly reserved or disclaimed its obligations.
The board didn't apply the kind of analysis it would have to if the court were to adopt the rule that we have suggested, or Mr. Gray's rule in this case. It took sort of the talismanic invocation of Burns and Kelly in this document as putting it into the 2 baskets we sort of described in our brief, and analyzing it that way. Whereas I think if it went back, the board would have to look at it under the new rule.
Thank you, Mr. Woods.
Thank you.
Counsel?
Your Honors, I'm Evan Perigo. I'm here representing New Hampshire Insurance Company and the employer Lehr Construction.
Counsel, I was sort of starting to get at Brisson a little bit just a second ago in terms of what the carrier has to do in order to expressly and unambiguously indicate that it's not responsible for any future payments. No determination was made as to whether your settlement agreement here did that, correct?
Right, and that is the argument that we raised in front of the third department and that we continue to raise here, that essentially.
Well, how did you do that? I mean, they reserved their rights under Burns.
Well, on page 43 of the record, if you'll consult it, it says that the carrier's lien is, the carrier's paying off its lien pursuant to Kelly. Now, under Kelly, the carrier only has an obligation to make one payment. Once that one payment is made, it extinguishes the carrier's obligation to make further payments towards the litigation costs.
Then why talk about Burns at all?
Frankly, it looks like, based on the course of the negotiations, the counsel for Terranova was trying to put in some kind of escape hatch or way out from the agreement that he was making.
So wouldn't you have had to have said, you agreed to those terms, and you signed that agreement, wouldn't you have had to have said, but that doesn't mean we owe you any more money?
Right.
Or something.
We certainly could have been more clear, but we take the position that it's almost as if we have a situation where someone is signing a contract saying the contract is going to be subject to New York law. Notwithstanding that, we'd like to reserve all of our rights under California law, and it just is, it's inconsistent.
But it's almost as if you're saying that you know there wasn't a meeting of the minds.
We can certainly say that we see an attempt to perhaps get around a meeting of the minds, but certainly we don't think that it was unclear to the people who were involved in drafting this agreement.
On both sides.
On both sides. It was an attempt at lawyering around this issue that shouldn't have been made. And really, in truth, since almost all of these consents to settle these third-party actions actually do happen by negotiation between the claimant and the insurance carrier, really, just getting clear on this issue is going to solve 99% of these cases without having to come to this court or any other court.
So I'm confused, all right? Let's say we're not talking about a schedule of loss of use. We're talking about some other kind of claim where payments have already been made at the time of the settlement of the third-party action, okay? But it's recognized that that there will be future payments, and they're not readily ascertainable, so you have a clear Burns situation, right? Is that
Yes.
a clear Burns situation? Okay,
Yes.
so are you saying that the carrier then never makes a payment or, however it's done, as to their share of costs at the time of the settlement, and then additional payments are made later on?
Right, it's a pay-as-you-go system
Right.
under Burns.
So something is paid at the time of settlement under
Right,
those circumstances.
But what normally happens is that the carrier actually gets to satisfy its lien against so the third-party settlement is usually made after the carrier has made some payments. So the carrier says, we paid some medical and indemnity benefits, we'd like that paid back, please, out of the third party. And in fact, one of
Well,
the...
and that's what happened here.
Yes.
And then the question was, is there anything else going forward? And in what you consider the true Burns case, then payments would be made going forward.
That would be the true Burns case, yes.
Okay, so why, I thought you said that once you made a payment under Kelly, that's it, that you never get anything else. Is that
I was
just-
interpreting Your Honor's question as being in an instance where you didn't have a schedule loss of use issue, essentially a Stenson case. Stenson was a case where there was basically no chance of there being a schedule loss of use, a death, or a total disability. That wasn't in the cards in Stenson. And so everybody knew that Kelly was never going to be applicable, and the appropriate award in that circumstance is to just start applying Burns before the Workers' Compensation Board gets to the point of resolving what the final classification of the claimant is going to be, and then to just keep paying Burns thereafter because it's going to be a permanent partial disability.
So it's just a matter of what you call it, really, whether it's, you're calling it a Kelly payment because this is what's ascertainable, and then a later Burns payment, or whether you're calling it all Burns or all Kelly. You're saying there can be no...
Certainly, I think
Overlap.
Judge Fahey's question earlier about can we have first some Burns payments and then a
Exactly.
final Kelly payment, that's something that's perfectly acceptable under the current regime. The issue is when the carrier is negotiating these consents, it's trying to produce the most favorable outcome for itself and is frequently going to ask for, we'd like to make one payment, and after that, we'd like to not make any more.
But isn't it kind of a sandbag if you do it that way? Aren't you really sandbagging the other party? I mean, 29-1 has some public policy implications that require a recognition of an equitable distribution of legal expenses. And the approach that you're taking undermines that.
I don't think it does, Judge. And the reason for that is that, and no argument has been made here for invalidating a contract, which is essentially what would be necessary. But there are times when you can invalidate a contract. Public policy is a perfectly good reason to invalidate a contract, as is the contract being simply inequitable. So if we had a situation where the carrier was contributing absolutely nothing, was taking a massive credit, that would simply be thrown out as unconscionable. Or as against public policy. That's clearly not where we are here. This is an issue about $3,000.
But
Whether or not
let's
it's
take the principle, though, because we're the Court of Appeals, so everything we do has other effects. So the principle would be that in this scenario, you pay no legal costs, right?
None. No,
Okay.
the carrier has had to make its contribution.
Besides your costs, I mean, in this case, though, yeah.
No, there has been some contribution. The carrier only got, was just a lesser amount because.
Well, what if the carrier had only paid a very small amount, that the settlement came even sooner than it did here? So then it would still meet that public policy?
As I said, there does come a point, and that's of course a point that a court should draw, where it wouldn't be an equitable distribution anymore, or an equitable portion of the legal fees. I don't think we're in that situation here. And in fact, one thing that I think is really important to remember, because we have the board essentially urging that claimants shouldn't be allowed to make these kinds of agreements with carriers, is that really more often it's the carrier that gives up part of its lien in order to encourage the claimant to go forward and do the settlement. Because in a lot of these cases, I mean, the whole reason for Section 29 is that we have claimants who really aren't in a position to get anything out of their third-party action because they're going to get more in workers' compensation benefits than they're ever going to get in their third-party case. So the whole purpose of this is to make sure that the claimant isn't settling for too little. That's what 29.5 is all about.
Do you have a difficulty with Mr. Wood's proposal that the board get additional flexibility and that we interpret our prior decisions to allow that instead of imposing categorical rules?
I actually think the first proposal that Mr. Woods made, and it's the first time I've heard it actually was today, it would actually be very much in line with this case. We have here is we have some folks coming to the board where we have the treating doctor and the independent medical examiner at the time of this third-party settlement both looked at this person and had both said there's no lost range of motion in this person's knee. The only basis for any kind of injury that they've got is that this guy had a knee surgery. And when there's absolutely no other facts like that, that is precisely the kind of circumstance where you don't have to wait.
But then someone came along and said, no, it's 55%.
Right.
And what if the board had agreed with that? Then what?
Well, we take the position that there was simply a 0% probability that that was ever going to happen.
Well, maybe it wasn't 55, maybe it would have been 35.
We take the position that there is simply no chance that the board is going to look at someone who has recovered the full use of their leg after surgery and that their own doctor has found this, and then going to award that person a schedule loss of use that's more than
I thought the
negligible, more
range
than
was
10%.
10% to 55%. I thought that's what we were talking about. The board's doctor versus the claimant's doctor.
Right. The board actually threw out Dr. McMahon's opinion the first time it looked at it, saying, actually, this is really an independent medical exam that you didn't go through all of the steps for. The board then wavered on that and overturned
But we
that.
can't make a rule based on the quality of the medical proof or a presumptive factual analysis
Well,
like that.
I think what Mr. Woods was advising the court in terms of his first proposed rule is that the Workers' Compensation Board in particular, all the law judges know this area pretty well. They can take a look at a case and they can say, you know what, at this point, I know where this is going. I know this is a Kelly case. This is absolutely going to end in a schedule loss of use and make that decision. But the really important
Well,
thing...
I thought he was talking about cases where there was no real dispute about that.
That might have been his second one,
part.
where there's an idea of something that's presumptive but not determinative. But I think the really important thing here is that because most of these cases settle with consent of the carrier and settle based on agreements that are a lot clearer than this one, and you can ask Mr. Gray about this when he's back up here, that and it's the carrier that has the real incentive to settle these because it gets most of the benefit. There's really not a lot of risk, even if this third department decision is left completely standing. Claimants have essentially the litigation upper hand to be able to say, I don't want to settle this right now, I'll wait for my SLU award, thank you very much, or you pay me more, or you agree that payments are going to be under Burns. It's pretty simple, and that's why we say that the court should find for the respondents.
Thank you, Mr. Perigo. Mr. Gray? Mr. Gray, are there any tripwires to the flexible approach that your colleague has
Yes, Your Honor,
suggested?
that was exactly what I was going to say. I think that the Attorney General and Mr. Perigo are both looking at the elephant here from the wrong end. What we're trying to achieve here, I believe what the court is trying to achieve here, what it said it was trying to achieve in Kelly and Burns and the Third Department said in Stenson, is a rule that plaintiffs and compensation carriers can apply when they're settling a third-party action. If the court decides that we're going to disregard the type of the settlement, and everything will depend on what the Workers' Compensation Board thinks the likely outcome is, then what will follow is a plaintiff's personal injury attorney will never be able to settle a personal injury case until the workers' compensation case has concluded, because there will be no understanding about whether this is a Kelly case or a Burns case or something in between. Not only that, what will happen is there will be innumerable motions to Supreme Court under Section 29(5), because that is the court that has the jurisdiction to decide this issue, and Supreme Court will be burdened with deciding what are essentially workers' compensation issues. As I started to point out before, and the Attorney General frankly has it wrong, I am not arguing that timing trumps the type of the award. What I'm saying is that timing trumps the type of the award if the award, rather than try to recharacterize what they say, what I'm saying is if it's not the type of award that is both subject to Kelly and has been determined before the date of the third-party settlement, then it's Burns. So both the timing and the type are relevant, but it's not a flexible rule. It's a rule designed so that everyone will know at the time the third party settles what they're dealing with, and they can make their adjustments accordingly.
Thank you, counsel.
Thank you.